You have 15 minutes this morning, sir. Did you wish to reserve some time in rebuttal?
I wish to reserve 5 minutes.
All right. When you get close to your time, I'll just I unfortunately have to just kind of interrupt you, sir. So I'll keep your time when you're ready, Mr. Barrett.
Thank you. C. Francis Barrett. My co-counsel is immediately to my left, Joshua L. Good, on behalf of the appellants, Bankers Choice and Stout Development Corporation. We, of course, believe that the trial court committed prejudicial error by dismissing our complaint and granting the city's motion to dismiss. Let me just clarify a couple of dates I think are helpful. The streetcar became operational in September of 2016. We applied for access permits in September of 2017. And we believe that's the most important aspect of the case. You really don't know if your access is denied unless you apply for an access permit, DOTE, Department of Transportation and Engineering permit application with the city. And those were reviewed after we filed in September.
I guess you knew that they were constructing right outside your client's property, right?
Yes.
And so was there not discussion prior to that about ensuring that you would have access notwithstanding the construction?
There were a lot of discussions back and forth about trying to get access. Yes, there were. But until you actually apply for an access permit, until the city actually denies it, you do not know that you're not going to have access or the city cannot accommodate you. And the city mulled these over, and it wasn't until January 24 of 2018 that the access permits were denied.
So under your view of the case, that's when the statute of limitations should start running.
That is correct. And with respect to the city's position, the city claims that construction began on May 6, 2015. Again, that's not a fact in our complaint. The city also argues that the foundation was completed on May 8, 2015. Again, that's a fact outside our complaint. But in looking at the city's motion to dismiss, the city relies on exhibits K and L to its motion to dismiss, which are daily reports dated May 6 of 2015 and May 8 of 2015. And in looking at those very closely, very recently, like last night, I noticed that you cannot tell that the construction work had been completed or started or anything. In fact, the far right column on both exhibits, where it says yes or no as to whether the item has been completed, they're all checked N for no. So by the city's own document, the city cannot establish what happened as of those two dates.
But Mr. Barrett, what are exactly are those documents, those exhibits that you're referring to?
Those are daily reports.
And their theory for them is that they're public records somehow? Is that why they want a judicial notice?
Yes, they maintain their public records, and the court, it's actually discretionary as to whether a court can take judicial notice, but the standard is supposed to be not subject to reasonable dispute. In other words, anything I send to City Hall becomes a public record. Any correspondence I send, anybody, if you were to write to the City Hall, if you were to submit something, all of those are public records. The standard is that they're not subject to reasonable dispute. This is the ultimate factual issue in the question. It is subject to dispute. And furthermore, looking at those exhibits, K and L, it appears that construction had not only not been completed, it was still underway. And it's very clear to me from looking at it last night that you cannot establish that the foundation had been completed. Furthermore, the test is not when it started, but it's when all of the events have occurred. The project is complete. The construction project is complete. They try to make it on the basis the foundation was completed. In addition to the foundation, you have the platform. On top of the foundation, you have all the improvements, the rails, the steps, the shelter house, the ticket facility where you get your tickets, the overhead electrical wires. All of that took place far later, so we're well within the statute of limitations. Again, going back to the primary issue, you have to exhaust your available remedies, your administrative remedies, before you can bring an action in mandamus for inverse condemnation. And until we applied for the demolition, or excuse me, for the access permits, and until those were denied, the statute of limitations could not have commenced. You really don't know what your access is or how it's denied until you ask for it, until the city denies it. And I also apologize for not bringing this to the court's attention, but last night when I was preparing, I noticed in the case of State XREL Hilltop Basic Resources, the city of Cincinnati, which I'm sure Mr. Tidd is very familiar with, it's cited in 2006, Ohio 3348. That was a case where the Court of Appeals, First District Court of Appeals, ruled against the city of Cincinnati, and that involved that the taking did not occur until the access permit was denied. All of the events which restricted access to the Hilltop property occurred long before. It wasn't until they applied for the permit, they had to apply for the access permit. And really,
Well, Mr. Barrett, I guess one concern I have with that is, like, what would prevent your client from just waiting several years to apply for the access permit and then saying, hey, we got denied, the statute of limitations starts now, even though the construction was completed several years prior to that?
first of all, that's a hypothetical question beyond the facts in this case. So I really don't know what the answer to that is. That would have to be something adjudicated at a later date. But here we have a situation where
Well, but let me ask you this, like, do you believe your client has an indefinite amount of time to apply for the permit in question?
no, we don't think so.
Well, then how long would that time period be in which you have to apply for that?
The streetcar platform was completed the streetcar became operational in September of 2016. We applied for permits in September of 2017. So we felt we were well within the time period.
Okay, thank you.
And again, until you apply for a permit, the city really can't review it and make a determination. I can bet my bottom dollar that if we had not applied for a access permit, we had filed a mandamus action for an inverse taking, the first thing the city would have done immediately would have filed a motion to dismiss on the grounds we A, hadn't applied for permits, and B, we hadn't exhausted our available remedies. So I think that in the city's brief, they absolutely cite no authority for their position that no legal authority, no case law, no city ordinances or anything for their position that on this particular issue about filing for the permit. They have nothing to say really. So again, that's our strongest point. But on top of that, again, looking at the city's own documents, until all of the events have been completed, the statute does not begin to run. And there's no way for the trial court, looking at the complaint to determine that all of the events have actually run. The court apparently relied on the city's position that a daily report showed that they did construct the platform only on May 8th of 2015. But again, looking at Exhibit K, which is a daily report for May 6th, and especially the Exhibit L, which is a daily report for May 8th, it appears that the construction was well underway and nothing was completed. Even the platform was not completed as of that date. I'll save the rest of my time. How much time do I have left?
You have about 7 minutes.
Let me save the 7 minutes if I may.
All right. Thank you, Mr. Barrett. Mr. Tidd.
Thank you very much.
Morning. May it please the court, Kevin Tidd on behalf of the city of Cincinnati. The trial court properly dismissed the Style Group's complaint because it is clear from the record that this lawsuit was filed outside the statute of limitations. Now the Style Group only has one claim. It has a sole claim for a lack of access taking claim for the city's construction of a streetcar stop along the subject building's Main Street frontage. And I bring that up because the opposing counsel's theory of the case has changed several times as this case has gone on. Originally, he claimed there were multiple theories of a taking based first just on the construction of the streetcar, and then it was based on the curb cuts. Well, it's not. There's just one taking claim that is alleged here.
Well, Mr. Tidd, let me ask you this. Let's go back to the actual documents that were attached to the motion to dismiss. So is it your position that these are public records, and are they self-authenticating, and that allowed the court to take judicial notice of them?
Yes, Judge, that is my position.
Well, were they certified though? But don't they have to be certified copies to be self-authenticating?
The way we looked at this was it was just like any other type of public records request when as the Style Group has made several public records requests related to this case, not every document you receive is authenticated. And these are documents that you would receive if you filed a public record request with the city of Cincinnati.
But you also have a bunch of emails in there. How are those even conceivably public records?
So those are public records. If the Style Group were to make a public records request, emails are probably the number one thing that people want when they make a public records request with the city of Cincinnati. So they're definitely
public record of which we can take judicial notice. Are you aware of authority that says we can take judicial notice of email correspondence?
So not emails specifically, but public records in general. So I believe Ohio law is clear that courts may take judicial notice of appropriate matters in determining a motion to dismiss without converting it to a summary judgment, and that includes public records. I think here,
But doesn't the act, I mean, what about the question, we have to question, can we question the accuracy of those public records? I mean, isn't that part of it? You know, if you attach an email and you say it's a public record, but couldn't there potentially be a question of the accuracy of that?
So I think there's always a fear for that, but there's always a fear every single time that we receive a public records request and we release public records. This is something that we deal with every day. We have an entire section within the solicitor's office that pretty much deals only with public records requests. I'm not in that section, but it's just common. And I would like to point out that the emails I attached, most of them, they are actually from the Stout Group. So they are, the opposing side.
Well, let's get to the question that Mr. Barrett was talking about, and your theory that the statute begins to run upon the completion of the foundation. I mean, like, why is that the magic line of demarcation here?
So I think what makes it, I look at that as the line of demarcation because the Ohio Supreme has determined that a cause of action against the government has first occurred only when all the events which fix the government's alleged liability have occurred and the plaintiff was or should have been aware of their existence. The statute of limitations in the takings case emanates from one event, the date of the original adverse determination by the government. Now here, notice is not in dispute. The Stout Group has had knowledge of the city's construction of the streetcar station stop. The Stout Group engaged in extensive correspondence with the city, and they also played a role in the planning process. But even more than that, the stop is entirely in the city's right of way, not on the Stout Group's property, but it is right in front of the property. You cannot miss it. And
Yeah, but
the Stout Group,
all of this sounds more like what you would pursue on summary judgment rather than on a motion to dismiss for the statute of limitations. I mean, you seem to have a very compelling case on summary judgment, but for a motion to dismiss when none of that is in their complaint, I think that's what's giving us pause.
yeah, and Judge, I completely understand that, Your Honor. But I guess what kind of makes working for the city a little bit unique and politically municipalities is that we do have public records readily available to us. So I had this, and it was conveniently not in the plaintiff's complaint, these dates, but I could provide public records that did provide dates for this. And that's why I chose the avenue that I did. In this case, the single completed act that gave rise to the Stout Group streetcar claim was when the city exerted permanent physical control of the sidewalk and began construction of that cement platform. The construction of the site with knowledge and over the objections of the Stout Group is the event that triggered the accrual of the claim. This act cut off permanent access to the right-of-way, was immediate, and has been continuous. No additional event needed to occur because the city never relinquished physical control of the site, but instead continued to construct a permanent streetcar stop on the platform. I would like to address.
Why doesn't the statute start running when the platform is completed as compared to you just started, you poured the foundation?
So the trial court basically ruled that it was at the completion of the trial court. I think it was a little vague whether it was.
Well, it was a little vague. That's what I'm
beginning of the
getting at.
construction.
Right.
At the beginning of the construction, right when we took physical control of the site, I believe is when the taking occurred.
So you think it's before the foundation is poured?
So I see an argument for both, especially in the case law, just because I think the case law is a little muddled, just some of the terminology they use. I'm okay with both dates. So I was okay with the trial court's determination. But once we seized control of that right of way and we exerted physical control of it, it was continuous. And it's, to this day, it's still there. I would also like to address the curb cut issue. The city does not provide an administrative appeal process for how it chooses to use its right of way. It doesn't matter whether it's a streetcar stop or a traffic light. And I would like to point out the Stout Group was actively engaged in the public meeting process and had notice of the streetcar stop, and it elected not to seek injunctive relief and waited years after construction was complete to finally file these applications for relief, for a curb cut, I'm sorry. I believe the curb cut applications were simply an attempt to extend the statute of limitations, which has also been mentioned here today. And it's really nothing more of an admission that the Stagger Group knew it didn't have access of the right of way. And I think as a final point, I would like to kind of look at this from the perspective of the property owner. And if Mr. Barrett's theory is correct, the property owner in this case would not be able to file an action for almost 2.5 years after the city took physical control of the site and cut off access to the area, which just doesn't make sense to me.
Well, what about his argument that it needs to run from the denial of the permit, or I'm sorry, whatever he was applying for?
So we have no administrative process for curb cuts. I'm unfamiliar with the case that Mr. Barrett cited, but I can tell you there is no administrative process for that. I think the notice and process argument it was in preparation for the building of the streetcar itself, for which they were engaged. And that's when the city effectively denied any of their requests to changes, is when we started building the streetcar itself. The city respectfully requests this court to affirm the trial court's decision to dismiss the Stagger Group's complaint, as this claim was clearly filed out of time. Thank you, Your Honors.
All right, thank you, counsel. Mr. Barrett, sir, you still have about 7 minutes.
Thank you very much. First of all, with respect to the application for permits, as we stated in our complaint, those are actual permit applications for the DOTE, Department of Transportation and Engineering. I think Mr. Tidd was not completely candid in saying in referring to the city's administrative process. There's no administrative appeal process when you file an application for a curb cut. There's no administrative appeal process from that. But the actual process of filing for a permit is part of the process. That's something you have to exhaust before you go into court on a mandamus action for inverse condemnation. You have to first apply to the city and be denied by the city. That's what we did. There is no appeal process from the denial of the permit. You go to court directly, but you have to file the application for a permit first. That is essential. And I think the real question that should be asked to the city is, isn't it true that if we had not filed an application for a permit, the city would have filed a motion to dismiss the mandamus claim on the grounds we hadn't filed for a permit? But it is a DOTE application. Our complaint alleges that, and there's absolutely no challenge to that on a motion to dismiss. Again, with respect to motion to dismiss, the facts must be presumed to be true, and the standard is that there's it's beyond all doubt that we could state a claim for relief. Not reasonable doubt or any doubt, it's all doubt. And again, the trial court, for whatever reason, got quite confused and focused primarily on the issue of the demolition permit. We had dismissed our claim for a COA, a certificate of appropriateness for the demolition permit, yet the trial court's primary focus was on the demolition permit, which is a moot point because those claims were dismissed. Again, with regard to the issue of judicial notice, it's discretionary, and the court may take judicial notice in some circumstances on a motion to dismiss of facts which are not subject to reasonable interpretation or reasonable dispute. In this case, it's the ultimate question of whether or not the construction had occurred and what had occurred. And again, looking at exhibits K and L to the motion to dismiss, it's pretty apparent to me that construction had not been even undertaken to any great extent. In fact, on May 8, which was the day in question of they claim the foundation was completed, it shows that there's still work on the removal of the sidewalk and removal of part of the curb itself. Again, on a motion to dismiss, those facts are not proper consideration for the trial court, and the trial court improperly considered those facts. And again, the standard is when all events that fix the city's liability have occurred, not just the foundation, but the platform itself, the improvements on the platform, the shelter house, and primarily other improvements like the overhead electrical wires. Until those have all been completed, the statute cannot begin. So for all of those points, I think the trial court was in error in granting a motion to dismiss. I'm happy to answer any questions that any of the panel members may have.
All right. Thank you, Mr. Barrett. Thank you, counsel, for your arguments this morning. Matters now submitted. We will thoroughly review the record and issue a timely decision. Thank you.
Thank you very much.
Thank you.
All right, let's move on to the next matter on the docket. It is C2000030. It's Ron Plush versus the City of Cincinnati et al. Good morning, everyone. On
Morning.
behalf of the appellant, is Ms. Warner, are you arguing on behalf of the city this morning?
Yes, Your Honor, I'm arguing on behalf of the city and its employees. However, Ms. Rutowski and I are splitting the appellant's argument. Ms. Rutowski will focus on the immunity for the police officers. And we would like to, I'd like to request 3 minutes for rebuttal.
All right.
And then I will take 8 minutes and Ms. Rutowski will take 4 minutes.
All right, I will do my best with my stopwatch here virtually to keep everybody in line, but as I said on the first one, I'll try and just give you a heads up if you're getting close to your time. So, but you have 3 minutes rebuttal, and then you can split your time. And then Mr. Gerstein, good morning. You're arguing on behalf of the appellees. All right, then Ms. Warner, when you're ready.
May it please the court. Emily Smart Warner on behalf of the City of Cincinnati and its employees. I'd first like to take a moment to recognize the tremendous loss that the Plush family has suffered. We remain so sorry for that loss. But the question before this court today is whether the city and its employees, its 911 call takers, its police officers, and former city manager are immune from liability. And because the facts in the complaint show that none of the employees were reckless and no other exception to immunity applies, the trial court erred in denying the city's motion to dismiss. Now, I'd first like to talk about—
Normally on immunity, it's done at summary judgment, and I think there's just some parallels between this case and the prior case where the city seems intent on going outside of the complaint and kind of resisting the characterization of the complaint. So maybe you could respond to that as well.
Yes, Your Honor. And this complaint in particular has many detailed allegations in it. I mean, it is a lengthy complaint replete with factual allegations about the city employees' conduct. And the city's motion has taken care to accept all of those facts alleged in the complaint as true and taking the inferences in the plaintiff's favor as you're required to do on a motion to dismiss. So that is distinguished here in that the city did not append any additional exhibits to its motion. These are the facts that were alleged by the plaintiff in the complaint. And as this court recognized in the Steele versus Cincinnati case about the Cameo shooting, when those facts as alleged, when you accept those as true, and it's clear that the city's employees at most were negligent instead of reckless, it is proper to dismiss or to find that there is immunity. Moreover, this case involves the city's own immunity. And here, there is hardly any argument from the plaintiffs that the exceptions to immunity for the municipal corporations immunity apply. So that is why it's different than the previous case and why this case, we are relying on the facts that this plaintiff alleged.
Well, what about the argument that it is the whole construct of the 911 system provides the pathway to get around the city's immunity?
Your Honor, that exception to immunity simply does not apply. So first, in 2744, where they lay out the exceptions to the immunity has to be, civil liability has to be expressly imposed by this other statute. And the General Assembly made it clear when they say, expressly imposed, where they say in the statute itself that, just because the city has a duty, that's not expressly imposing liability, or that, there's another statute that says shall. I mean, that is the text of the exception in 2744. And when you look at the code provision that plaintiffs have cited to, revised code 12832, you will see that is an additional immunity statute. It is far from expressly imposing liability on the city or its employees. It is in fact adding another layer of immunity for 911 operations. And on top of that, the reading that the plaintiffs want this court to take of that particular statute doesn't make any sense.
So is there any
the
way
statute
to,
applies.
under your theory, is there any way to impose liability on the city in connection with a mismanaged or a misoperated 911 system?
No, not that the General Assembly has applied. We are dealing with statutory immunity, and when you apply those words as the General Assembly has enacted them, there is no exception for the city's immunity in this case. But I also want to highlight to the court about the immunity of the city's employees. The Supreme Court has recognized over and over that in cases like this, for the municipality's employees to lose their immunity, they have to act either willfully, wantonly, or recklessly. Here, there's no allegations that there was willful conduct that resulted in harm, but at a minimum, the plaintiffs have to demonstrate that the conduct was reckless. And the recklessness is a conscious disregard of a known or obvious risk of harm. And the employee has to know that the conduct will, in all probability, result in injury.
Well,
And that is
explain,
what-
can you get to the 911 operator Smith and explain how the complaint does not at least show negligence with regard to that individual?
Your Honor, for Amber Smith, the 911 call taker, the complaint does not show the requisite recklessness.
I mean,
Because
I
the-
meant recklessness. How does the complaint
What?
not rise or show that there was at least recklessness for this person?
Because the decision that when you're looking back in hindsight, the decision that could have gone differently was her decision to engage the TTY function. At the point that she decided to engage the TTY function, she simply did not hear most of that call. And those are the facts that are alleged in the complaint. And so that decision she was making because she was trying to make sure that there wasn't a hearing impaired caller that was trying to use the TTY to communicate. That is far from a conscious choice to say, I'm going to engage this TTY function, and I know that in all probability, this choice will result in injury. That is the standard that the plaintiffs need to allege, and that falls short for call taker Amber Smith.
Well, but then when that failed, she also then failed to contact the supervisor when the CAD froze. So, I mean, isn't that just compounding the mistakes?
Your Honor, the complaint does allege that she failed to contact the supervisor. But again, at that point, you have to look
At that point, the officers were still on scene, weren't they, for at least 2 or 3 minutes?
Yes, Your Honor, that is true. But again, you have to look at whether that decision to allegedly not tell the supervisor when the CAD system was freezing, whether that was recklessness, whether that was a conscious disregard of this risk that you think in all probability will result in injury.
How can we know that how can we know that at this point in the litigation though? I mean, that goes back to Judge Bergeron's original question. It seems like we're just looking at these allegations, and don't we need more information in order to decide if it was reckless or negligent?
Yeah. Judge Krause, I see that my time is expiring, but in this case, when you have extensive allegations, factual allegations, when you have references to expert reports in which those experts had enough facts to form preliminary conclusions, this is a fully fleshed out complaint. And that is why if the facts in the complaint do not establish that the employees were reckless, then a finding that immunity applies is proper. And I will yield the rest of my time to Ms. Rutowski on behalf of the police officers.
All right, thank you. Ms. Rutowski?
Thank you. May it please the court, Kim Rutowski for officers Edsel Osborne and Brian Brazil. I think it's important that we separate the police officers and look at them individually from the other city defendants. First of all, this was a tragic, unimaginable accident, but the officers, they were not provided with all of the information that the dispatchers had at the time. They were told that
They
there
were
was,
told that he was trapped in a van, correct?
correct, a female caller was trapped in a van,
But they
possibly.
didn't search any van or like look in the windows of any van on the premises, did they?
They looked in a van up by the thrift store. They were in the thrift store parking lot. And that's where they had gone through. They were on scene for 11 minutes. They went and they looked, and it's important to recognize also that school was letting out. There were a lot of cars and individuals in the area at the time. And that's where they saw Deputy Doug Allen in front of this thrift store parking lot. And they asked Deputy Allen if he had seen anything out of the ordinary. And he actually looked at their MDC screen, recognized, saw that it was a female trapped in a van, and there was nothing out of the ordinary.
What crucial information are you saying that they were not provided?
They did not know all of the information that Defendant McGee has, as alleged in paragraph 66, that she could hear banging, that he was screamed twice, there was urgency, the desperate need for help, and that he was going to die soon. These officers, they knew it was unknown trouble, someone trapped in a van. The obvious risk of harm, there has to be obvious risk of harm. And if you're trapped in a van, it's not obvious, it's almost unimaginable that someone would be trapped underneath the rear seat. The folding seat would have malfunctioned and trapped someone underneath the seat. Weren't
they provided though with a code number that indicated the severity of this call? Isn't that in the complaint?
A high priority call?
Yeah.
Yes, they were.
So you're saying that wouldn't alert them that there was some major problem going on inside the van?
It's an unknown trouble, high priority call, and they did go and they searched and they looked.
But the complaint alleges that they were provided with the address of the location and they went to the parking lot, but they didn't search the entire parking lot. Isn't that what the complaint alleges?
That's absolutely, but that would be at most negligence. They searched the parking lot. They were also told that he was possibly in the thrift store parking lot, and they searched that lot. When you look at, there are pictures in the complaint, there is a lot that is right in front of the thrift store parking lot. The van was located north of that location. They searched the lot that was right by the thrift store lot, and that is also where Deputy Allen, the off-duty Hamilton County deputy, was directing traffic. And I think it's important also that the complaint alleges that there was failure to train the officers on that technology as far as being able to locate, pinpoint the wireless location of the caller. They also allege that, that there was a failure to train on the unknown trouble, the high priority unknown trouble call. So they were doing what a reasonable officer would do and look for trouble, look for someone trapped in a van, and they did that. They drove through parking lots for 11 minutes searching for any indication that there was trouble, and there was no indication.
So you don't think that the complaint at least raises a recklessness standard when it alleges that they went to the parking lot, but they didn't search the entire parking lot? I mean, doesn't that rise above negligence in that regard?
I would no, they searched the lot that was immediately adjacent to the thrift store, which is where the location that they were told that they possibly in that thrift store lot. I think that would at most raise to negligence when you have a deputy sheriff that's there directing traffic and there's no indication that there's a problem at all. I think importantly, the obvious risk of harm. What was the obvious risk of harm as alleged in the complaint? 2020, we know that there was a risk of harm, but the fact that this bench flipped over and trapped Kyle Plush, that that is not foreseeable, or even that would not have been obvious to the officers at the time. If they had gone in front of that van, how would they even have seen him?
Well,
So
but I think that's the question. Like, they didn't get out and search to see if there were any vans, and if they had searched, then we probably wouldn't be here at this point.
I think that's difficult to say as well. Again, he was trapped in the back of the van. I don't know that these officers would have seen someone trapped underneath the rear seat of a van. They were looking for someone trapped in a van. I just don't think that.
Well, I mean, I guess it somewhat matters, like how many vans were in the parking lot, which we don't know from the face of the complaint. Like, if there was 1,000 vans, it's unrealistic to expect them to search every one. But if there were 2, that's a different story.
That's true. And we don't know that at this point.
You are at your time, counsel. Thank you.
Thank you.
Mr. Gerritsen.
May it please the court, along with Jennifer Branch and Caroline Hyatt, I represent the Kyle Plush family. The detailed 36-page, 191-paragraph complaint with 2 preliminary expert reports demonstrates that no defendant is entitled to immunity in this case. The case should proceed to discovery and trial. And I'd like to jump to the defendant that was raised by the panel, Defendant Smith, the second call taker. The allegations about her were at paragraphs 95 to 124 of the complaint. The city actually misrepresents the complaint when it claims that Smith heard none of Kyle's second.
Counsel,
I think we just lost him.
we lost him. We still has his screensaver's up. Keith, you want to try and get Mr. Gerritsen back? We don't. All
Volume's not working.
Hello?
right, there you go.
All right, I don't know what happened. Sorry about that.
Hold on, let me reset your stopwatch, the stopwatch, counsel. That I won't charge you for that time. Go ahead, sir.
Thank you. So she heard that Kyle was asking for help at the beginning of the call. He even said he was in the Seven Hills parking lot. At the end of the call, she also heard Kyle saying, "Hey Siri, hey Siri." And so we know also that while she was on the phone trying to figure out what this call was, she pulled up the first CAD, which goes to the serious risk of harm. She read it. She saw that Kyle was trapped in a van, and that and that he hadn't been rescued yet. So she chose to activate the TTY, and for some reason she didn't play it back afterwards to see what she had missed. And she chose not to contact her supervisor. She chose not to make any record at all of this second call. And that's her job.
Does the complaint allege that she actually heard the statements that he made or not?
Yes. Yes. At 103 and 111, she heard statements from Kyle at the beginning and the end. In between, she may not have heard his full text in between the beginning and the end, but she knew enough to say this wasn't a silent call, and she should have played it back to hear what she had missed. Most important is that she didn't even contact the officers at the scene who were there when Kyle was still alive. And of course, we know that during this call, she was on overtime, as is alleged in the complaint. And she had been posting that she hated overtime and she hated her job. So the facts here in particular are more egregious than any of the 3 cases we cited at pages 6 and 7 of our brief about 911 operators that aren't granted immunity. And it's more egregious than Chevalier versus City, where there was a delay in dispatching a call. Here, there was a complete failure to advise dispatch and advise officers on the scene.
Well, and so on that point, there's a little bit of tension between your argument that the first 911 operator was reckless And because she did not inform the officers of the severity of all of the risk, and the argument that the officers acted recklessly when they didn't have the full picture. So maybe you could respond to that.
Well, I think it's interesting that the officers are pointing the finger at McGee. I would contend that both are reckless and wanton. First of all, with respect to McGee, she had a 4-minute delay, she had a 7-minute delay in posting anything. That was more than the 4 minutes that were deemed reckless in Woolacott. And she did exclude critical information about what she knew. She excluded that there was that he was away from the phone, that he warned he was going to die soon, and that there was pounding. But those officers had enough. This was a high priority call. They were actually given an address. And if they had just typed the address into their mobile data computer or into their phone, they'd have gone to the north end of the thrift store lot. They never went to the north end of the thrift store lot. That address comes up right next to where Kyle was actually located. They chose not to do it. They were eating, they were playing the radio. They literally thought this was a prank and said that when they were interviewed about this incident. They didn't treat it as a high priority call. They didn't search the whole thrift lot. They never left their car. And going back to McGee, she had a second opportunity to save Kyle, because that deputy that was discussed earlier, who was at the scene, he called and McGee picked up the phone and she's talking to this deputy while Kyle's still alive. She never gives the deputy any specific location data about Kyle. So,
but I'm confused on that point and from the complaint, because the complaint does say that the officers did have specific location information, right?
They had
so obviously they got it somehow.
They got an address from McGee, but they didn't use the address from McGee. What they didn't have from McGee were all her automatic location information. She did what's called a manual ALI. She did like 6 of them, and we showed a diagram in the complaint. So there was no, she didn't tell them exactly what she had learned. Understand that we're talking about a parking lot. So if you get an address and you know that it's a parking lot, you know there's not going to be a building with a house number on it. So my position is that these are officers who are supposed to be trained in this. And this is all stuff, look how deep we are in the weeds. Just take a break and realize that we need to try this case. But this is all stuff that we need to flesh out. The officers had an address, they should have used the address. But they're going to look at the scene and maybe say, since there's no buildings, I'm not going to use the address. I don't know what they were trained or how this goes, but this is something, remember our standard that this is an immunity defense. The defense has to be conclusively established from the face of the complaint. There's no way on all of these facts that are so detailed that the defense is established conclusively on the face of the complaint.
Can you address Harry Black really?
Yes, most dramatically is the fact that a council member said that the whole 911 system was playing Russian roulette with the public. And even more dramatically, Harry Black knew from the time he became city manager that he had a situation where there was lack of supervision, there was lack of training, there was understaffing that was very severe. The technology wasn't working, it was freezing. The entire system was going down from time to time. Officers were not getting out of their cars on unknown trouble runs. Dead people were not being found. All of that's in the complaint at paragraphs 26 to 52 and 131 to 157. But even more dramatically is 2 months before Kyle died.
Does he need to have a role in this particular event to impose liability here?
As long as Kyle is in the foreseeable group of people to be harmed by all the deficiencies that he was responsible for, that is a foreseeable risk that is serious enough that he's on the hook. And in this case, 2 months before Kyle died, a supervisor in the 911 system, in the emergency communications section, comes to him and says that there is mismanagement that rises to the level of a public safety concern. She says this poses a risk to members of the public. She's trying to raise the alarm. And what does he do? He transfers her out of the emergency communication system, totally retaliating against the whistleblower. So he had his head in the sand. He was not taking responsibility, doing his job to make sure that the system was running correctly. And in that regard, the complaint adequately establishes facts from which you can find that he was reckless and wanton.
Mr. Burns, do you mind addressing whether the section 128.32 expressly imposes liability on the city?
Yes, I'd be glad to. And I think the best, one thing that's really important to remember from counsel's argument is that when asked if there's any way that a city can be liable under 128.32 for the operation of its 911 system, she said no. That can't be right. And the way, immunity can't swallow up every possibility of liability in a system that is designed to give the city exclusive control over it. The public is paying a surcharge on every one of our cell phone bills to go to the city to be a public safety answering point. And the way the statute is set up is it does set a higher bar. It says it'll only be liable for wanton misconduct by an employee, but it does say that the city will be liable for wanton misconduct for bringing into the operation the 911 system pursuant to this chapter.
But bringing into operation is different than actually operating or maintaining, right?
No, I think that is an ongoing process. And it also says development. And development, just using a dictionary definition, is caused to evolve or unfold gradually. The only time limit in the statute is setting standards. There's no time limit on following those standards. And it doesn't make sense that there'd be a time limit on following standards. We want the 911 system, if we're going to give such power to these public safety answering points, these cities, we want it to operate consistent with appropriate standards. And we'll set a high bar, wantonness, in order to trigger liability only in those situations where it's deserved. And that's what this statute does. And that's why we think that statute does fit 2744.02 B5, which is civil liability imposed by a statute.
So what about, the city's saying that if we interpret the statute the way you want us to do so, then there's no 911 system that's ever going to be immune from liability. Anytime there's an issue with 911, you can have a lawsuit. So it's really going to open the city up to a lot of litigation.
Well, she should take that up with the legislature. They wrote the statute, but they also wrote it to trigger liability only with wanton conduct. And that's a high bar. I mean, and I'm not, claiming that every piece of negligence is wanton in this case. It just so happens that we have a group of defendants who did act in a wanton manner. They had a CAD from the first call that showed them that there was a person who was trapped in a van, who couldn't be heard, who couldn't hear the call taker. And they chose not to get out of their vehicle in the case of the officers and actually go to the place where they were instructed to go. And they chose not to look inside the vehicles. And this, we're describing between the misconduct of the two call takers and the two officers and Harry Black, a tragic amount of wanton and reckless conduct. So I don't think that this opens the city to every missed 911 call. And remember the first district case of Myrick, where there is an instruction, an emergency instruction by the call taker to the caller, and this statute exempts those types of emergency situations where you got to make a on-the-spot decision as to what kind of instruction to give to a caller. So the statute's well designed. The city's we're not opening up Pandora's box. We're simply holding the city liable in those unusual incidents like this, where there is a complete and utter failure to serve the public in the way the statute's supposed to be serving. And I would note, by the way, that if, as we have alleged here, there is, for some reason, any holding that these defendants are immune, this is just the type of situation where there should be an inferred direct cause of action under the Ohio Constitution. Article 1, Section 1 gives something unique in Ohio, which is an inalienable right to safety. And Article 1, Section 16 provides a remedy for injuries that are done by—
Are you like making a Bivens type argument?
Yes, it would be a Bivens type argument, but under the state constitution, only available if the other remedies are not available. It's an argument in the alternative. And I just point out, we noticed in the complaint that the chief admitted, the chief of police, that something went terribly wrong here. The mayor himself says we failed. And yet, if the city can't be sued under all of the ways that we have identified for all of the conduct we've identified, at least this case should be remanded to flush out what the elements of a cause of action would be under the Ohio Constitution. Let me just briefly close. Ron and Jill Plush have started something called the Kyle Plush Answer the Call Foundation. They and their volunteers have visited over 100 911 call centers, and they meet with these staff members and they challenge them to answer the call to be your best self every day. And in this case, what they're seeking is that this court affirm the trial court and deny the motion to dismiss so that there can be full discovery. We can learn every detail about what happened to their son, and we can let a jury decide whether Kyle's cries for help were met with reckless or wanton responses. A full airing of these facts will help these defendants and other 911 responders be their best selves every day and may just save a life in the future. Thank you.
All right. Thank you, counsel. Ms. Smart-Warner, you still have your rebuttal time.
Yes, Your Honor. A few points I'd like to make in rebuttal. First, it is not the issue that is squarely before this court, but the city every day since this incident happened has worked to improve its 911 system and deliver a system of excellence for its citizens. So the technology has improved. We have engaged in other reports to improve our system. So this lawsuit is not the way to force the city to improve. We are continuing to improve, and we will hear out every suggestion so that we can ensure that this tragedy doesn't happen again. But what this lawsuit is about is whether under the statute as written by the General Assembly, the city and its employees are immune. And opposing counsel is asking you to apply a statute that does not exist. Those words do not exist. When you look at 12832, the word developing, it's modifying whether you're entering a plan or an agreement to create this 911 system with other jurisdictions. In order for 12832 to even apply, it has to be about bringing into operation a 911 system. That it doesn't apply to the facts of this case, and it certainly is not a section that expressly imposes liability. And then for our employees, the allegations in their lengthy complaint, which is the facts that they are presenting in the best light for their case, show that defendant City Manager Black was trying to change the 911 system. He changed it from civilian to police control. He was engaging in a complete overhaul of the computer-aided dispatch system. That is not someone that was acting recklessly. That was someone who was taking action to make improvements. And finally, for call taker McGee, and to compare her to the dispatchers in Chevalier, the dispatchers in Chevalier didn't do anything for 2.5 hours. Absolutely nothing. That is so far from what they have alleged defendant McGee did.
Well, but I think
provided
the most significant thing related to McGee is that he said he was concerned he was going to die soon, and she didn't relay that to the officers and kind of convey that sense of urgency of the request.
Yes, Your Honor, but it's important that she categorized this as the category 2 call, which is a high priority call.
But is it the highest priority? Like, I was confused on that.
No, it's not the highest priority, but based on the facts that she had on this call, I mean, they point to the
Well, I
delay
guess what would be higher than I'm going to die? I mean, why would you not categorize that as the highest, most urgent category?
Your Honor, I think that the choice of whether to categorize this as a high priority or a higher priority, you have to go back to whether that's negligent conduct or reckless conduct. But in the totality, she took her time. The delay in the dispatch was because she was listening to the playback of the call, something they say that, you know, Defendant Smith should have done. So she was trying to get the information. She conveyed that the caller could not hear the call taker. She conveyed the correct address. She categorized this as a high priority call. So to say that those decisions, that she was making choices that would in all probability result in injury is not something that's supported by the facts of the complaint. So, Your Honor, I understand that this is a difficult case, but you have to look at both whether the statutory exceptions apply for the city and each of these employees as an individual when you are doing this analysis. And when you look at the extensive facts alleged in their complaint, which we have accepted as true, there is not any conclusive evidence that these employees were anything other than at most negligent. So we respectfully request that you reverse the decision of the trial court and find that the city and its employees are immune.
All right, thank you, counsel. All right, thank you all for your arguments this morning. The very difficult, tragic case. We will thoroughly review everything and we will issue a timely decision. So thank you again for your arguments this morning.
Thank you.
Thank you.